Hey guys. Hey guys. I am here. Hold on, I got. I come to Dallas' house to sneeze. I am sneezing my elbow. I'm sneezing in my elbow. This is my elbow. Dallas is good. Yeah. I come to Dallas' house, and all I do now is sneeze, 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 sneeze. She got this dog here.
Before you get into that, I downloaded this app to record me talking in my sleep when I go to bed.
Oh Lord, y'all. This girl's getting on my nerve.
We're talking to.
She recorded herself while she sleep.
And then there was another one where it sounded like some knocking.
Dallas is.
Scary.
She recorded herself sleeping.
I never seen them. And then I found out I snore.
You been snoring. You should know that. Sorry, y'all. Hold on a second. Let me pull up these files. Hey guys, I have some of the motions and the filing. Dallas, I'm live. I have the files that I've downloaded that I got today. Yeah, and my allergies is kicking my butt, y'all. I come in her house and I think I'm allergic to her dog. He got pollen on him and it's making. But I'm sneezing like crazy in here, y'all. Sharon, I'm allergic to something because my throat is itching, y'all. I just took some medicine and pray for your girl, y'all. Allergies, animals, dogs, babies, Ruth. Hold on, y'all. Let me open this up. I gotta pull it up for y'all. Hold on. My throat is itching so bad. I apologize. I gotta figure out where. I think this is it. This is done today. No, what was done today? Today's what? The 20th, right? Okay, hold on, y'all. My ears itching, everything itching. Oh Lord. Just 1 second. I'm trying to pull it up. My nose. What happened? What happened?
Trying to gag on his spit.
See, that's why you need.
Look at my face. That smell like Doritos. That smell like Doritos.
Ruth, you're talking too loud. Yeah, I'm trying to find out where I put the file just now. I downloaded it. Where the heck I downloaded it to? Hold on. Did I put it here? I think I put it there. Let's see. Oh my God. I think I got it right here. Hold on, y'all. Try to pull it up. Let's see. My apologies, guys. I was trying to pull it up, but I can't. My allergies bothering me like crap. It's not that one. See, this is not today. I downloaded it. I put my marker on it. Now I'm trying to figure out where is it. Hold on. Let's see if I can find it.
is about to be 4:20.
Oh yeah. I know I should have it ready for you guys, but hold on. Lord Jesus. I didn't title it. Mm-mm. Mm-mm. All right, guys, I'm trying to figure out where I put it at. Maybe I didn't add it on the computer. Hold on a second, guys. Let me cancel this out and see if I have it in my files here. Hold on. I know I just did it. Nope, it's not there. Anybody good at this Mac stuff? It says open, recent files, and I did it today. Hold on. Hold on, let's go back up. Let's see, downloads. I found it. I found it. There it is, y'all. There it is. I found it. I found it. There it is. Okay, I got the files, y'all. All right, so we're going to go ahead on and talk about the guy, Merrick. He wants to represent himself, and the state submitted a motion in regards to that motion that he submitted to submit itself. I'm allergic to cats. Me too. I'm allergic to cats like crazy. Let's see. I think the medicine's starting to work a little bit. But a few minutes ago, it was, you know what? I moved away from the doorway, y'all. The doorway was a lot of like sneezing and all that craziness going on.
The air comes in at the bottom,
Uh huh.
and that pollen might be flying in.
Flying in here. Don't you use a filter? Did you filter it?
I need to get a humidifier.
Okay. Sorry, guys. Yes, please hit the like button. What I'm getting ready to do is pull up the motion from the state responding to the motion that Merrick's attorney put in for him to represent himself. So here we go, guys. Let's see. Let's see. Let's see. Let me go open that up. Hold on. I'm gonna open it up. All right. Let's see. Present. All right, we go. There we go. There we go. Here we go. There we go, guys. All right. This is the motion that the state submitted. State's response to Jaden Merrick motion for a FARDA hearing. So FARDA hearing, I guess, is to see whether or not he can represent himself. Guys, can you see this? Let me move ourselves out the way here. Make it bigger. Can y'all see that? Let me make it bigger in the chat. 1 second. You know, Syria, I'm gonna need you because this I Apple product, it just be like getting on my nerve. You know what I mean? It really gets on my nerve because I don't know how to really navigate myself around it. All right, I made it bigger. Is that bigger for you guys? Can y'all see this? Can you see this, right? Okay. All right. Here is the response, state's response to Jaden Merrick's motion. Okay. And it's for a FADA hearing. So it's a hearing to see whether or not he's competent to be able to stand um, and represent himself. You know what they say? Thank you, Sierra. We need to exchange information so he can help me. I need to learn a lot. I don't know how to do this, and learning to do this on Apple is like, ugh, crazy, right? But anyway, um, you laughing at me? Oh, I thought Dallas was laughing at me. All right. It says here the state of Georgia, by and through the undersigned district attorney, Fannie T. Willis, hereby respond to defendant Jaden Merrick, March 15, 2023, motion for a FODA hearing in support of this response. The state shows the following. All right, there we go. Oh, I gotta move down. Defendant Jaden Merrick is charged in this indictment with attempted murder, OCGA 16-4-1, 16-5-1, possession of a weapon by an incarcerated individual, OCGA 42-5-18, conspiracy to violate the RICO Act, OCGA 16-4 14-4. C. And participation in criminal street gang activity. OCGA 16-15-4B. Number 2. On December 19th, 2022, Gina Bernard entered her appearance as Merrick's counsel of record in this case. Exhibit A. Number 3. Jury Jury trial proceeding began in this case on January 4th, 2023. That's not right, y'all. Jury didn't start until January 9th. So that's incorrect on this thing here. Number 4. On February 27, 2023, Anne Long entered her appearance as co-counsel of record for Merrick in this Exhibit B. All right. In this case, Exhibit B. Number 5. On March 15th, 2023, Merrick filed a motion for a FARDA hearing in which it was represented that Merrick had expressed to his current counsel a desire to represent himself. Exhibit C. Merrick now asks the Honorable Court to determine whether he is competent to represent himself in this matter. Number 6. A criminal defendant has the right under both the state and federal constitution to represent himself and waive his right to counsel. See U.S. Const. Amendment 4, Georgia Const. of, I guess, Constitution, right? Of 1983, Art 1. Okay, we don't need to read all that. All right, so those are case laws, okay? An unequivocal assertion of the right to represent oneself made prior to trial should be followed by a hearing to ensure that the defendant knowingly and intelligently waived the right to counsel and understand the disadvantage of self-representation. They gave a case on that one too. Number 8. Be valid. Such waiver of the right to counsel must be made with an apprehension of the nature of the charge. The statutory offense includes within them the range of allowable punishment thereunder, possible defense to the charges and circumstances in mitigation thereof, and all other facts essential to broad understanding of the matter. Each case must be evaluated on its own facts and circumstance, and there is no magic language that the trial court must use to determine whether a waiver of counsel is valid. Stinson versus State, and it gives you a case law on that. The state currently make no assertion as to whether Merrick's request to represent himself is unequivocal or whether it is timely. Nor does the state have any position on whether Merrick is competent to represent himself. However, the state believes that this honorable court should conduct a further inquiry to make these determinations and to this end provide the attached proposed fodder colloquy, Exhibit D. Number 10. If after conducting a fodder hearing in conformity with the principle outlined above, this honorable court finds Merrick competent to represent himself is in the trial of this case, the state requests that standby counsel be appointed to assist Merrick as appropriate in this representation of his defense. See Stinson, and then give a case. A trial court may appoint standby counsel for an accused wishing to represent himself at trial, even over the defendant's objection, provided that standby counsel's role appropriately limited. See McKellar versus Wiggins. Appointed by standby counsel over self-representation, representative defendant objection is permissible. Respectively submitted this 20th day of March 2023. That was submitted today, y'all. So basically what they're saying is that they have no objection to him representing himself, but he should have a standby counsel just in case he needs somebody. Did y'all hear that? He should have a standby counsel just in case. Just in case. And I'm going to show you the question. The good thing is here's some of the questions that they're going to ask. Just something else to prolong the process. He clearly shouldn't be representing himself. But Syria, you know that's his right. He can represent himself. But you know the state is going to make sure they have somebody there so it don't become a mistrial because of some messiness and stuff, you know. They want to make sure that every angle is covered. All right, let's go down and see what else is sorry about my breathing. You laughing at me? My throat's starting to itch again. And this is them certifying that it was sent. And substitution of counsel, here's what undersigned counsel hereby enter her appearance. This is when they originally brought in, if you look at the date over here, this is December 19th. This is the date that they brought in Miss Bernard, Gina Bernard. There she go right there. And then here, down here, you have certificate of and then this is the other attorney that was on February 27th. That's his Anne Long. It has her appearance on that. And then you have motion for the further hearing. And this is where his attorney submitted this on March 15th, Mr. Merrick. It says, here come now defendant Jaden Merrick by and through his undersigned counsel and moves this court for a further hearing in the above style case as defendant wants to exercise his right to represent himself. And this is on March 15, 2023, Mr. Merrick and his assigned counsel had a conversation outside the presence of the court. During that conversation, Mr. Merrick expressed his desire to represent himself as his own, as he knows his right and has that right. Okay. Then number two, undersigned counsel requests the honorable court to conduct a fair hearing to determine if defendant Ms. Jaden Merrick is competent to represent himself in this trial. So she submitted that on the 14th. And here is the certificate of service. And then here's the FARDA waiver. Here's the thing that they have to submit, and Mr. Merrick has to answer these questions, I guess, during the FARDA hearing. Do you guys see that? Hold on a second. Hold on. Sorry. Oh, gotta bring it back up. Hold on, y'all. I don't know what I did. Hold on a second. It's acting up. Hold on. I gotta come back. Hold on. Did I take it down, y'all? Yep, I took it down. Hold on a second. Let me bring it back up for you guys. Okay, let me bring it back up. My apologies. I took it down by mistake. Me and this thing is not having fun here. There we go. Now, these are the questions that they're going to be asking them during this hearing, this FARDA hearing. Faretta, whatever, how you say it. Hey, Frank. Let me say hi to the people in the chat while I go ahead. Hold on a second. Let me say hello. I wanted to get this started. I was having allergy problem earlier. Hey, Sierra. Hey, Mika. Hello, Nosy Rosie. Hello, Sharon. Hello, Rob. Hello, Wanda. Let's see. Hey, VK. Hey, Galatian. Okay. Hey, Rob. Hey, Kitty Queen. Sierra. 444 Smile. They said anybody who represent themselves has a food for a client. Amen. Trissy, good afternoon. Hey, Linda. Kevin is in the house. Frank, hello, Frank. Ashley, Bree. Okay, so let's go ahead and read some of the questionnaire. Okay. Okay, this is the question that they have to see. These are questions he's gonna have to answer in front of the judge and find out if he's competent enough. Okay. I know the last guy, they convinced him not to represent himself, but let's see if this guy do the same. All right, here we go. First question they're gonna ask, number one, do you understand that self-representation is most always unwise? Do you understand that you may defend yourself ultimately to your own, I guess it's supposed to be to your own detriment, but they put to you own detriment. Man, they should have checked these spells check on this thing. I thought I was reading it wrong. It's supposed to be to your own detriment, but they put to you detriment. Number three, do you understand that you entitle? Oh my Lord, y'all, look at this. Do you understand that you entitle? It's supposed to be you are entitled to no special treatment by the court if you represent yourself. And number four, do you understand that you must follow all the technical rules of substantive law, criminal procedure, and evidence for the making of motion, objection, and representation of evidence, jury selection, and argument argument even if you do not know those rules? Oh Lord, that alone would be like, nah, I'm not representing myself. No, I don't know the rules. I don't know all of that because you're still going to be held accountable whether or not you understand it or not. That's like crazy. All right, number 5. Do you understand that you will have to abide by the same rules that it took years for lawyers to learn? Oh, Lord. Y'all, there's no way. There's no way I would represent myself based on those 4 or 5 questions already. Will any of you guys represent yourself after you hear this? Hey, will any of you guys represent yourself after those first couple of questions? I know I wouldn't. Give me a hands of all those that would represent themselves. Give me a hand of everyone that would represent themselves in this case. You know what? Let me put the link in there. Maybe somebody would like to come up and talk with me a little bit about this. This is like, yeah.
Don't stand by the door and be loud, man.
Go downstairs. Go downstairs if you're gonna be loud. Absolutely not. I wouldn't even need to see these questions. Ah, me neither. There's no way I was sitting there. Even when I was being represented the other day, the last week, or was it the week before? I don't know what the heck the judge was saying. I was like, there's no way. There's no way I would represent myself. Give me the best lawyer my money can buy. Exactly. Sharon said no. Josephine said hell no. Dallas, would you represent yourself? From the question? Dallas says the dumbest thing ever. I know. I know, right? She said she get the driving laws messed up. So you can imagine if you know the legal jargon, you can defend yourself in your land. If you are educated in the canon law and marital law, I don't know, but and morality, I don't know how to say that. Law jurisdiction, you can represent yourself. It is fear that stops us. Sandra, you know what? I'm gonna call you to represent me next time. That's I'm gonna lose. Are you in school, Sandra?
My friend, she's in law school right now. She got these big books of the different laws.
Uh-huh.
That's exactly why I would never do that. There's so many ins and outs.
Look, VK said lawyer for 1,000, Alex. Toya said even lawyers have a lawyer. Exactly. I can't. I don't care. There's no way. All right, let me finish with these questions. I was up to what, number 6? Okay, let's go to number 6. If you don't know the difference between a mercy law and the natural law of the land has an African American natural law of the land as an African American, you have to stay in slave status. Well, let me stay in slave status then, because I don't know the law. I do not know the law. And I ain't going to sit here and pretend like I do. I do not know the law.
I don't think anybody knows the law unless they pass that bar.
Yeah.
None of us know the law.
Didn't Avenatti represent himself for the story? Yup, he sure did. And where'd he go? He went straight to jail. And he's an attorney. He went straight to jail. Let me tell you something. Every court case that I've gone to and heard about people doing that sovereignty thing, every single one of the judges like, don't come in here with that nonsense. I'm telling you, every single law person that I've seen, I watch a lot of court cases, right? I'm talking about in person and stuff like that. I used to go. I would prefer to have an expert than myself than just to know the basic. Oh yeah, yeah, yeah. I got you, Sierra. But look, every person that I know who went to do that sovereign citizens thing. I remember this young man in Gwinnett County, and he was caught with some marijuana, right? And his dad and his mother was in the courtroom, and they were trying to do that sovereignty thing with him, right? The judge told him, "You continue to let your parents guide you, you're going to end up with 100 years in jail." And then he ended up he kicked him out, right? And he only ended up getting probation for 6 months. He says, "You let them come in here convince you that what they say in is law, you end up getting 100 years in jail because he was selling marijuana in the school." Yep, he was selling. I think he bought some brownies or something with drugs in it, and he gave it to the kid. This was in Gwinnett. I gotta find the case for y'all. All right, let's finish these questions and hold on. All right, we were up to number 6. Number 6, do you understand that if you represent yourself, you are assuming full responsibility for your defense? Number 7, do you understand that you may miss important defense to the case because of your lack of knowledge of the law? Number 8, do you understand that even if you have some knowledge of the law, you will lose the benefit of depending I know, right? You will lose the benefit of an independent perspective of an attorney and in analyzing and reviewing and presenting the case in a most effective way. But now there's some lawyers that suck now, y'all. There's some lawyers that suck. That even though they've been spending many years in school. Now, do you understand if you are found guilty, you may be able to represent the case in a manner to obtain the most favorable sentence? Number 10. Do you understand that your access to the DA's district attorney will be reduced, making it more difficult to defend yourself because you will have less of a chance to work out a favorable resolution? Okay, I'm going to read that one again. Do you understand that your access to the district attorney will be reduced, making it more difficult defend I guess to defend yourself. It's to defend yourself. That's a grammatical error there, right? To defend yourself because you have less of a chance to work out a favorable resolution. Number 11. Number 11. Let's see. Do you understand that the prosecution will be represented by an experienced and skilled attorney? Number 12. Do you understand that the prosecution's attorney will treat you just as the prosecutor would treat you as other attorney? The prosecutor will not go easy on you because you represent yourself. Number 13. Do you understand that you will not receive any special treatment or help from the court? They keep saying that one. Uh-huh. If you use big words, hey, we okay if you don't understand it. Do you understand that if you behave in a disruptive manner in the courtroom, the court can terminate your self-representation? Number 15. Remember that guy that was representing himself in Milwaukee? Yeah, you remember how much of a fool he acted? And what? He lost. Because everybody's like, oh my God, this dude again. You remember how you was just like, did y'all get a chance to see that case with that guy? The one in Florida was, ooh, he was just a fool. Daryl Brooks, yes, that was his name. Yes, Daryl Brooks. You got that. Thank you, K baby. Yep, Daryl Brooks was just man. That man was just a fool representing himself. He just like, ooh. All right. They make it hard for you to defend yourself.
My thing is, why would you think it?
Okay. Yeah, Avenatti will. Hold on a second. Hold on. All right, let's go back. Let's go on. What number was I at? Number. Oh, number 15. Number 15. Do you understand? If you get convicted, you cannot claim your own incompetency as a basis for appeal. Do you understand that you will not be given any extra time to prepare the case for trial simply because you are representing yourself? And number 17, if you are incarcerated, do you understand that your ability to investigate, research, and prepare for your defense will be severely limited? Now, that alone, it's in itself, is something to really think about. Because how are you going to be able to get access to certain things if you're in jail? Hmm? They're not making any special accommodation for you.
I think it's a setup.
It is a setup. Why would you do that to yourself?
My thing is, why are you gonna let people do that? To be able to put them in jail.
It says Sierra says, I don't even think they're making it hard for you. They're just saying you are a novice and what we don't care if you want a chance to get someone who can compete. Mike, I watched it from the beginning to end and he already knew the outcome. He was trying to delay. Yeah, he was. Yeah, at this point, just stick it out with a lawyer. Thank you, VK. Because you're really gonna lose. Why do all of that? What's that?
Chicken Caesar salad wrap.
Oh, Dallas cooking up some chicken Caesar salad right, y'all. Y'all should see her food. Looks good. What happened to your potato soup?
Oh, I had that for lunch.
I thought you gonna eat the separate fry I bought. All right, yeah, sorry. Let me go back and finish reading it to you guys. Number 18. We're at number 18. Do you understand that you had a lawyer? Listen to this. Do you understand that you had a lawyer and the lawyer would not be subject to those limitations? Okay. All right, let's go down. Now they're gonna give you the advantage of having a lawyer. Hold on. Okay, why's my computer sticking, y'all? Yeah, this thing is sticking. It's not moving. I'm on page 13. It's not moving, y'all. What the heck is going on? Dallas, could you tell me? Okay, there it is. It's moving, y'all. Why is my thing taking its time? It's not moving, guys. I don't know why it's not moving. I don't know what I did just now. It's I don't know why it's moving like that. What did I do? Okay, y'all. What did I do? Sierra, what did I do? Um, it's it's copying something. What the heck did I do? Dallas, what did I do? It's like it's highlighting stuff. What did I do? Look. You see? What did I do? It's like highlighting. Huh?
Just click something.
I'm
I'm
doing.
saying click. You type it. You click the mouse.
Click my mouse.
Like, you click it anywhere. Stop it from this home.
I clicked it somewhere.
Stop clicking it. Or did it?
No, it's still there.
What is that?
It's thing.
Mm.
You see now moving. It's like, oh Lord, y'all. I don't know what I just did. Why it's not let me bring up the other thing? Oh my God, what the heck did I do? Okay, yeah. I don't know what I did. Let's keep doing that. It's move. Hold on, y'all. This thing's moving by itself. I'm gonna wait till it finishes. I gotta wait till it's finished acting crazy. I don't know what I did, but it's acting crazy. Don't ask me what I just did, okay? I can't keep come back to the screen to even look at y'all. I gotta wait. All right, I stopped now. Okay, here we go. Sorry, guys. I don't know what I did, but All right, here we go. Going back down. Now it says the advantage of having an attorney, a lawyer. Number 19. Do you understand that you have a right to an effective assistance of a lawyer at all, I guess all, they put L, at all stages of this case. And if you cannot afford a lawyer, the court will appoint one to you, appoint one to represent you. Number 20, do you understand that the lawyer would select a jury to try the case, including questioning and trying to remove those jurors who would not be good juror for you? Number 21, do you understand that the lawyer may make an opening statement of the to the jury about your side of this case, about the side of the case? Number 22, do you understand the lawyer will subpoena witnesses for you, question witnesses against you, and present physical and documentary evidence on your behalf? 23, do you understand that the lawyer will object to the prosecutor's question and evidence? Number 24, do you understand that the lawyer on may make various motion on your behalf, such as motion to keep out prosecution evidence, to dismiss the case, and to give you a new trial? 25, do you understand that the lawyer will argue your side of the case to the end to the juror? Number 26, that was 26. Number 26, do you understand that the lawyer will prepare and give the court legal instruction for the jury which would be favorable to you? 27, do you understand that the lawyer will argue your leniency at sentencing if you are convicted? Charges and consequences. 28. Have you received a copy of the indictment and accusation stating the charges against you? 29. Have you read it? 30. Do you understand the charges against you? 31. Do you understand the possible penalty in the case if you are found guilty of all charges? 32. Do you understand that if you are not a citizen of the United States and you are found guilty of the charges, you will be deported from this country, excluded from entering this country, and denied any opportunity to become a naturalized citizen of this country? 33. Do you understand that once the trial begins, you cannot then change your mind and ask for a lawyer to represent you? Background of defendant. 34. What is the date of birth? What is your date of birth? 35. How many years of school have you completed? 36. Can you read? 37. Can you write? 38. Do you have any difficulty understanding or speaking English language? 39. Have you previously represented yourself in a civil or criminal case? 40. Why do you think you could do a better job than a lawyer in representing you in this case? 40. That's a good question right there. Yep. 39. Okay, hold on. 41, I'm sorry. 41. Have you ever been under care of Have you ever been under the care of a psychiatrist, psychologist, or any other mental health professional? Oh, okay, here's the waiver. Has anyone threatened you in any way in order to get you to waive your rights to have a lawyer represent you? 43. Has anyone promised you anything in exchange for giving up this constitutional right to and have an attorney represent you in this case? 44. Do you specific, uh, do you specifically waive your right to have a lawyer represent you in this case? All right, that's the thing that he has to fill out and swear and all that kind of stuff for him to be represented himself. And if the judge find him competent, he will be able to represent himself. Didn't they say that the trial already technically started? So how is he able to switch now? Huh. That's a very, very good question. That's a very good one, Sierra. How is he able to switch now if the trial has already started? Very good question. All right, that's a very good question. Okay. That is that on that. But you know what? I wanted to bring up a case for you guys. This is have nothing to do with the YSL. I just want to bring up something. This is something that came about the other day. And this is for educational purpose and for commentary. Hold on a second. All right, y'all. This is the weirdest thing, y'all. I'm gonna share this with you guys. I'm gonna share this one with you guys. This is about a person who robbed the bank, right? He robbed the bank for $1 so he could go to federal prison. He robbed the bank for $1, y'all. He went to the bank and submitted the letter to the clerk, to the teller, and says, "I'm sorry for doing this, but you are being robbed for $1. Give me $1." Hold on, I'm gonna read it to y'all. Hold on. You seen that? You seen that stupidity? And that's probably what it was. He was sick and tired of paying bills, y'all. He wanted to spend some. Yeah, he's 65 years old. Hey, Sean! Hey, sweetie pie! Y'all, they got my baby, Sean Davies. Sean, what happened? You know, you and I got to talk. You know, you and I got to talk because Payne said something and y'all never called me back. I want to know what's going on. But anyway, we got to talk. Hey, I'm so glad to see my baby. All right, y'all. You read the article too? Yeah, he went. Let me show y'all him. Let me show you this man. It's crazy that he went to the bank to rob the bank for $1, and he wanted them to send him to federal prison. And this is in Utah. Utah, y'all. This happened in Utah. This is crazy. Hold on. Let me bring it up for y'all. Bruce, you're talking too much. Ruth is talking too much, y'all. All right, here we go, y'all. Here we go. Here's the case. Here we go. Education purposes for crime and law and crime. Look at him, y'all. Look at him. Look, look. He coming to the teller. He give him a note.
A 65-year-old man robs a bank for only $1 and demands police send him to federal prison. Former inmate Big Herc, who did a decade in federal prison for bank robbery, comes on.
Okay. That's basically what this man did. He went to the bank to rob the bank for $1 for them to put him in federal prison.
But it don't even work like that, do it?
He went to county jail.
I'm about to say, don't the amount gotta be a lot more? To go to federal.
I would think so, but he went to jail. He went to county. He didn't get the the jail that he wanted. Hold on a second. I'm gonna bring it up for y'all. I'm gonna share it with y'all. I actually bring you the case itself. Hold on a second. Once if the commercial for this is over, then I'll put it up so you can hear it. This is advertisement right now. Four, 3, 2, 1.
Bank robber got just what he wanted, to stay behind bars. He says he wanted to go to prison, so he held up a bank and asked for just $1. Court records in Salt Lake City show the 65-year-old man entered a Wells Fargo bank, handed the teller a note that read, "Please pardon me for doing this, but this is a robbery. Please give me $1. Thank you." Well, the teller gave him the money and asked him to leave, but instead he asked the teller to please call the police. He reportedly later told officers that he wanted to go to federal prison and planned to rob another bank if he was released.
Every time he come here, he want to have a fit.
Okay, y'all.
This scared me. He got mad.
Y'all hear that, y'all?
He kept sneezing. He got mad.
So y'all see that, right? Micah said, "I heard about that." And then VK said, "LOL, what?" And then Sierra said, "Rent and groceries too high. He wanted free room and board." Yes, you heard what Dallas said. Times are hard. I ain't trying to go to jail either. How's pork chop? Pork chop, look. Y'all want to see pork chop? Hold on. Oh. He was sneezing in here, so he's having a fit. We at Dallas's house. There go Ruth right here with him. You see him, y'all? Y'all see him? Look. Y'all see the thing. I had to improvise because he kept scratching his face. What I did, I put a rubber band on his I put a rubber band on his shirt. I'm gonna show y'all. Let me show. Can I get him? So I can show. Look what I did with them. Look what I did. Look what I did, y'all. Look what I did. His hat. Look. Hold on. Let me fix his hat on his head. Let me show y'all what I did with him. Look. I put a rubber band on this. Look. 'Cause I didn't want him to scratch his face. And I didn't have a look. Ah, hey Red. I had to put look. I put a rubber band on it. Look. I improvise. Cause his clothes so big on him anyway. So I look, when you don't have the actual item, you improvise. Got his socks. Everything's so big on him, y'all. Socks, everything big. These are newborn clothes, and they still too big on him. Look at him. He's so mad. Look at him. He's like, look, lady, look at his mouth, y'all. Look at his mouth. Look at his mouth. I be improvising on his foot. Look, those socks that they got him. Look how big it is. They don't even fit. They don't even fit, y'all. He tired of me. Look, he's so mad with me. Look at him. Look at his face, y'all. Sir, look at him. Look at his lip. Look at his lip. He got a lip like this. He's so sick of me. Look at him. Look. Hey, look at his pants, y'all. Look how big these pants are on this poor baby.
Pants on the ground. Pants on the ground.
Look at him.
Turn sideways.
Look. He tried to scratch his face. Look.
Walk around town with your pants on the ground.
He was scratching his face up like right here, y'all. He was just scratching. Look at his face. Look, he was scratching his face up. Look at his lip, right? Like he was scratching his face up, but I had to figure out some way to stop him from scratching his face up. Look at it. Look at the side of his face, y'all. No, he's scratching his up. Look. He was snatching his mittens off. So I said, you know what? I'm gonna improvise. Look at this. I said, Dallas, you got some rubber some rubber bands, and I improvised. Look. All right, y'all. I'm gonna go ahead and do the next set of reading. Here, Ruth. Whoa! Got to take him back. Look at him. Still trying to scratch his face. Look. Still trying to scratch his face. He's still trying to scratch his face. All right, y'all ready for the next? He's gonna get you when Randa, yep, he is. He's gonna get me. But I had to put something on there because he was like, okay, all right, okay, y'all. I'm gonna show you guys what are some of the items that that the judge threw out on Young Thug. You know, the one with the search warrant? Because if some people was like, oh no, he got this, he get to keep that. But let me show you guys all the items that the judge ruled in favor of the defense. Okay, let me show y'all. Hold on, here we go. Let me share it with you guys. Cynthia, he is getting big. He is getting bigger. Who's that? Kobe?
Yeah.
And also they submitted some new file. And guess what, y'all? I do have the transcript. I have the transcript, but I figure I'll read that tomorrow since I don't have nothing to go to court for tomorrow. So I'm gonna read the transcript tomorrow. Maybe we can have a reenactment of the transcript or something. All right, here's what they that the judge. This is the order that the judge did in suppressing certain items that was taken from the home during the search warrant. Remember that back in November. Okay, we're gonna read them and make it bigger so you guys can see it. 1 second. Make it bigger. Tell me if that's big enough for you guys to see. Let's see if you guys can see this. Is that better? Can y'all read this? You go into a meeting this time of night, Mika? All right, you ready? All right, this is the motion that to suppress. Remember, Mr. Steele. All right, thank you, Sierra. Okay, State of Georgia versus Jeffrey Williams. Yeah, I know the indictment number and all that. Order granting defendant Jeffrey Williams motion to suppress number 1, supplement to motion to suppress number 1, motion to suppress number 2, and motion to suppress number 4. So number 1, 2, and 4 have been granted by the judge. Okay. Defendant Jeffrey Williams filed a motion to suppress number 1 on September 27, 2022. Motion, supplement to motion to suppress number 1 on October 3rd. Motion to suppress number 2 on October 28th, 2022. And motion to suppress number 4 on November 9th, 2022. All 3 of these motions seeks to suppress items seized pursuant to a search of Mr. Williams' residence located at 315 Glenglade, whatever. And it says on July 15, 2015. And all derivative evidence therefrom. All derivative, not some, all derivative evidence therefrom. This court heard argument and considered evidence from the parties on November 17th. That's where I have the transcript from November 17th, and I have the transcript from just the November 17th transcript I have. Okay, I have another transcript, but that was from prior date. Okay, as well as December 15th. After consideration of the evidence, arguments, and legal authority, this court hereby grant defendant Williams' motion to suppress. In doing so, make the following of fact and conclusion of law. Ready? On Wednesday morning, July 15, 2015, law enforcement entered Mr. Williams' home located at, the address. The entry into the subsequent search of the resident led to the seizure of Mr. Williams' property, including the following. Okay? Y'all hear this? The following items were there. Okay, number 1, iPhone 6 cellular phone, and gave the EIME number, right? Item number 2, a desktop computer manufactured by the Apple Corporation, and they gave the serial number for the Apple computer, right? So that means anything that they had on that computer cannot be used against them. But you know what? They're going to be like, it was in the cloud. So if they have a search warrant for the cloud to get, but they're going to have to search to see if it's all in the cloud or not, you know what I mean? Okay, y'all listening? Are you guys listening to me? All right, let me go finish reading. I had to pop in to see what y'all was saying because, I don't know how to do that split screen thing where I'm reading and talking to you guys. I only got it, the thing covers it for me. All right. Huh? Take it to the bathroom. Okay. All right. Is that enough space? Oh. So it's good. Can you do it on the couch? On the chair? On your bed? Yeah, put a blanket on the bed. I'm sorry, y'all. Then number 3, another desktop computer, and they give a serial number for that. And then number 4, a computer hard drive manufactured by HDX Corporation. Number 5, a computer hard drive manufactured by G. Gelip Corporation, and give that number. Then a black compact Presio laptop computer, and it gives the sticker and including a number of. It has a Braves and stuff on it. It says a little pig digs or whatever. Then a 16 gigabyte SD card labeling item 21. Then number 8, a Verizon tablet computer. Number 9, a computer hard drive manufactured by Western Digital Corporation. Then number 10, a computer hard drive manufactured by Western Digital Corporation. And number 11, a computer hard drive manufactured by Western whatever, another computer. Law enforcement also seized gun, jewelry, and marijuana. Pursuant to the entry in so all these other stuff that they mentioned was part of the stuff that they got as well. The gun, the marijuana, and all that, right? Pursuant to the entry and search conducted at that home, whatever that home was, the seizure item by law enforcement, the Fulton District Attorney Office charged Mr. William in accusation number whatever in Superior Court, Fulton County. Mr. Williams counsel on accusation, whatever the number is, as was attorney Brian Steele, his current counsel in this case, and through counsel, Mr. Williams filed a motion to suppress evidence seized from July 15, 2015, as well as a supplement thereto. A hearing on the motion to suppress was conducted on April 3rd, 2017, and at the conclusion of the hearing, the court specifically Superior Court Judge Newkirk granted the motion to suppress and supplement thereto pursuant to a written order dated April 11, 2011. April 11, 2017. Sorry about that. See Court's Exhibit Number 2, motion transcript date and April 3rd. April 3rd, 2017. The state filed a motion for reconsideration, which was denied. The state did not appeal the suppression of the evidence, and the accusation, and it gives the case number, was ultimately null poised. This court finds that as a result of the court's order suppressing the evidence, it was the duty of Fulton County District Attorney's Office and any law enforcement officer or agency working with the prosecution team to restore and release and return Mr. Williams all non-contraband evidence seized on July 15, 2015 search. Further, this court finds the defendant Williams and his designee timely request that all of his non-contraband property return to him, but the prosecution team refused. The state's refusal and failure to restore, release, and return these items constitute a violation of OCGA 17-5-30B, which provides that if a motion to suppress is granted, the property shall be restored unless otherwise subject to lawful detention, and it shall not be admissible in evidence against the Marvit in any trial. The court finds that the state's retention and the search of seized non-contraband property, even if the faces of specific requests to restore, release, or return these non-contraband items by Mr. Williams, counsel, and authorize this designee constitute a violation of Mr. Williams' right to protected by the 4th Amendment and 14th Amendment of the United States Constitution. Article 1, Section 1, Paragraph 13 of the Georgia Constitution, as well as OCGA 17-5-30 et al. This court finds that any and all, listen y'all, any and all warrants for search and seizure of Mr. Williams' above discussed property, including the warrant issued on June 27, 2016 by former magistrate Judge Woodsum, and any other search and or use of any of these suppressed items that were seized in July 2015, July 15, 2015, including but not limited to the iPhone, are unlawful and warrant were not served in compliance to OGCA 17-5-25, which provide that any search warrant not excluded within 10 days from the time of issuance shall be void and shall be returned to the court of the judicial officer issuing the same as not executed. Thus, all evidence and derogatory evidence obtained from any item seized from Defendant Williams' residence on July 15, 2015 is suppressed as fruit of the poisonous tree and is inadmissible in the indictment on trial. Y'all hear that? Did y'all hear that? Okay. Let me finish reading. It gave a case number. It says, okay. Is covered and was suppressed by the April 11, 2017 order and under the well-settled proceeded established by Wong Sung versus United States, and then they give a case number. All derivative evidence obtained therefrom is inadmissible as the fruit of unlawful search and seizure in the indictment on trial. This court finds that the pursuant to OCGA 17-5-30B, the state must restore, release, and return all non-contraband property seized on July 15, 2015 to Defendant William, his counsel, or his counsel's designee inster. Based upon the above, defendant's motion to suppress number 1, motion to suppress number 1, supplement motion to suppress number 1, motion to suppress number 2, and motion to suppress number 4 are hereby granted. That so ordered this 21st day of December 2022. So guys, y'all heard that, right? So anything that was found, remember when I asked last week on your live, that's why I brought it to you, Courtney. You asked for it. You're the reason why we got it from the court papers. Courtney, I remember. See, I remember this. Remember? I went and got it so I could read it to you guys. That's why I got it, because you brought it up. Thanks to Courtney, guys. I went and got it. Okay? I went to get, because I wanted to read it. Remember I said I did not know the facts of what was missing with all that? Because remember I was trying to find the transcript. And also I got 2 transcripts, guys, that I am asking you guys to support the channel so I could read these transcripts for you guys. I did go ahead and purchase them ahead of time, hoping that you guys will help to ease the pain of this financial burden of me pulling all this stuff up. You see, I'm doing the work, y'all. See? Okay, so any questions, people? So that was the items. They can't use that in this case. So, that's gonna be tough to get to. After reading that, that's gonna be very tough to get him. That's gonna be tough because. So that's why now I understand, and I am not gonna now understand why because they're trying to get more things to add on to help the case to secure a win. So now because they threw out all those the gun and all that. I mean, they can't give them back the gun, but they got to give them back the other stuff. Okay, they can't give them back the contraband, the marijuana. They can't give them those things, but those things cannot be used against him on. They can't be used against him. So that means those witnesses can't even say anything about those items because they got the item without a proper search warrant. And he submitted some more suppression. I'm going to give you another stuff that was submitted today. Mr. Steele is putting a lot of things in to suppress in Mr. Williams' case. So we just have to, the other co-defendant who was released. We'll have to see. Baby King, Sion, we have to see. We have to see what goes on because you know what? I can't say anything. All I can say is what's in the document, on the docket, We have to see because we don't know what the testimony is. Also, didn't somebody, Dad, say that they were bribed? Yeah, remember Courtney? I had him on my channel. I do have that testimony on my channel. You have to go back. Who agree with DNA? DNA and what? What DNA? You sleep? You mad at you? So let me sleep, lady. Did you give him? Did he drink his milk?
Drinking.
Huh?
Yeah, I warm it up. You keep not trying not to drink it.
Maybe the nurse needs. So you're going to go to the doctor tomorrow, sir. Look at his face, y'all. Look at the face. Look at the ugly face he's making. He is making an ugly face. He ain't even asleep. He just got his eyes closed. Yes, ma'am. I remember. I pay attention to your page. Thank you, Courtney. Who agrees with DNA? Plus 8 hours. AN has favor. What's AN? Look at this. Look at this one. Look at this little thing. This little thing. Wolf, he's stinky. He come and get him. He's stinky. Oh, you just scared him. You made noise, ma'am. You just made him. Look at him. Look at him. Sir, you need to drink. Babies don't drink water, do they? Yes, because his. Okay. The co-defendant, all 8 of them. All 8 of them what? What is it? What are you saying, Baby King? You keep throwing out stuff I don't understand. You're throwing out subliminal messages, and I don't understand it. Queen said, great news. What's the great news, Queen?
It ain't cold, man. So I don't get it. Okay. You don't keep fighting me? There you go.
You drinking? Okay.
You go open. You get his time off for his time. So your time? Mm-hmm. You have slow noises, man. Such a cute.
Okay, what happened to why nobody's talking?
So, fill it out.
He doesn't want it. You want to get a paper towel or something. You don't have why you don't carry your bib and stuff with you. You gotta come on, you gotta do better than that, mother. You gotta carry burp cloth and all that kind of stuff for the baby. Why you laughing, Della? Stop laughing.
Look at that.
He do want it, Mom.
Oh.
He does.
See, you still going.
Okay. All right. So that is that part. And there was another. Let's go ahead on and pull up the next motion that he submitted today. So that was the motion for them to. There's another motion that was submitted today. And this is motion to suppress number 8. This was submitted today. Yeah, family duty. They threw out 9 out. 90. What was? I'm hearing this case against YT has been weak so far. Is this true? McCain, I don't know. I don't know what, I mean, I can't speculate. Now, Queen, where did you hear that from? I want to be able to pull that up. Where did you hear that from? Because you know me, I have to have some concrete proof before I put things out. You know how I am. Where did you hear that from? Let me go see. Was it on Twitter? Was it on the document? Because I don't want to put no fake news out. I have to put things that are, have some sort of concrete proof behind it. And McCain, you know how I am about this. I have to show some concrete proof on what I am reading, what I hear. I'm not one of those that's doing things for click and views and stuff like that. I like to put out real good information.
That first I heard it. You got another one? That one?
Okay, let's see.
You try one more again?
Queen, are you still there? Queen, if you're still there, please put in where you found that at, where I can go find it.
There you go.
Okay. You can email me if you have it. Quality over quantity, always a good. Yes, quality over quantity. Always a good thing. Amen. Amen on that one. Let me go ahead and give you the motion that was submitted just recently. Hold on. The one that was submitted today. I'm going to go ahead and read this to you guys. All right, let's go ahead and just present this. All right, here we go. Sorry for the nasty noise because my sinus is starting to act up again. Okay, motion to suppress number 8. I guess this is like some of the charges that they have. Suppress number 8. Okay. Now comes Mr. Jeffrey Williams by and through undersigned counsel and hereby files this motion to suppress any and all statements made during a traffic stop initially conducted by City of Brookhaven Police Fikes on September 24th, 2017. In support of this motion to suppress, number 8, Mr. Williams shows as follows. Number 1, Mr. Williams is innocent of all charges in the above referenced indictment. Number 2, on or about September 24th, 2017, Mr. Williams was wrongfully stopped by a passenger in a vehicle, detained and handcuffed and interrogated. Number 3, Honorable DeKalb County Superior Court Judge Adams heard the evidence on a motion to suppress statement and suppressed same. Wait a minute, this is like the other one. Another judge had already made a ruling, so is this going to be the same situation like the last one that I just read? That a judge already made a ruling to suppress something and now the state is bringing it as part of their evidence? Huh. Guys, I don't know, McCain, you might be right. Hold on. All right, y'all. Okay, let's go. Let's finish reading this one. Okay. So it says here that the judge in DeKalb County District Attorney's Office conceded and agreed to the suppression of these statements. Oh, wow. See unpublished opinion footnote number 3 in State versus Williams, Court of Appeal, number A19A1893, decided March 12th, 2020. So it went to the appeals court. Oh my goodness. And see footnotes number 1 in Mr. Williams' motion in limine, number 4. Okay. All right, guys, let's see what's going on here. Okay, let's go down. Number 4, since this case has already been litigated, res judica collateral estopolel double jeopardy bar the admission of these statements because this was litigated between the same parties. This is one state of Georgia and Mr. Williams. Ooh, y'all, did y'all see this part too? Number 5, Mr. Williams was not read Miranda rights while being interrogated while in custody. Hence, all statements made by Mr. Williams at the time of this traffic stop must be suppressed. Oh, Lord. Y'all, did y'all hear that? Did you guys hear that? Did y'all guys hear the Courtney father didn't say that his father's Courtney father didn't say that his father said he tried to get him to say, but trying to bribe him and he didn't know them like that he don't hang with them, and how can he tell on? Y'all, did y'all hear that? Who heard that? Who heard that? Give me hands up. Hands up. Hands up. Hands up in the air. Hands up. Who heard that? Hands up in the air. Hands up in the air. Tell me. Who just heard me I see Black Beauty has heard exactly what I read on there. His Miranda rights was not read to him. Ooh, child. And the judge agreed to it. The other judge agreed to that. Ooh, child. Uh-oh. This case is corrupt. Blink and Stitch said, etc. says, wasting taxpayers' money, and I stand firm. He says, free thug. Okay. Y'all heard that? Y'all, let me read that one again. You know me, I like to repeat stuff a couple of times so people could get some full understanding in this. It says here, that this case had already been litigated, res judicata, collateral estoppel, double jeopardy bar, the mission of these statements, because this was litigated between the same parties. This is one state of Georgia and Mr. William. Number 5. Mr. Williams was not read Miranda rights while being interrogated while in custody. Hence, all statement made by Mr. William at the time of this traffic stop must be suppressed. Wherefore, Mr. William respectfully requests a hearing on this motion, and at the conclusion of the same, asks this honorable court to grant the above request relief. All right, now, so if this gets suppressed, this 20th day of March 2023, respectively submitted, Brian Steele. Okay, look, guys. He even put in the case, y'all. Look at this. 4th Division, Doyle P.J., Coomer, and Markel J.J. This notice motion of reconsideration must be physically received in the clerk within 10 days of the decision and deemed timely filed, right? This is the Courts of Appeal, and this is, it says State versus William, State versus Jones, right? And the Cedric Jones was charged with possession of methamphetamines with intent to distribute, possess of hydrocodone with intent to distribute, possession of marijuana with the intent to distribute, possession of amphetamines, possession of alprazolam, possession of codeine, and possession of a firearm during the commission of a felony. Mr. Lamar Williams was charged with possession of methamphetamines with the intention to distribute, possession of hydrocodone with the intention of distribute, possession of marijuana with intention to distribute, possession of amphetamines, possession of alprazolam. I don't know how to say that, y'all. 2 counts of possession of codeine and possession of firearm during the commission of a felony. The defendant moved to suppress the evidence seized during the traffic stop, and the trial court granted the motion. Oh my God. Okay, y'all. Could somebody answer this question? The motion was granted. So why do we have this in this case? If the motion was already granted in the other case, why are they trying to bring it in this case when it was already decided upon? Did y'all see that? Suppress the evidence seized during the traffic stop, and the trial court granted the motion. Did you see that? Did y'all read that? The state appeals, and we reversed for the reason as follows in this consolidation appeal. We review the ruling on the motion to suppress as follows. First, when the motion to suppress is heard by the trial judge, the judge sits on the tier of facts. The trial judge hears the evidence, and his findings based on conflicting evidence are analogs to the verdict of a jury and should not be distributed by reviewing court if there is any evidence supporting them. Secondly, the court's decision will, with regards, hold on. I gotta read it. Hold on, I gotta go back now. The court's decision, let me go back up. The trial court hears the evidence, and his finding based on the conflicting evidence are analogs to the verdict of the jury and should not be distributed by a reviewing court if there is any evidence to support them. Secondly, the trial court decision with regard to questions of fact and credibility must be accepted unless clearly erroneous. Third, the review court must construe with the evidence most favorable to the upholding of the trial court's finding and the judgment. On numerous occasions, the appellate courts of this state have invoked the three principles to affirm trial court's ruling that upheld the validity of seizure. These same principles of law applies equally to trial court ruling and that are in favor of the defendant. Y'all hear that? This standard of review requires us to focus on the findings and fact that by the trial court its order and the evidence supporting those findings, rather than other evidence gleaned from the records, construing in its favor of upholding the trial court's order. Okay, so view the records shown in that at approximately 7 p.m. on September 24th, 2017, a Brookhaven police officer noticed a dark-colored Mercedes with mirrors.
You should put the blanket on your lap so if you throw up.
Oh, yeah.
Why don't you just lay him across your lap so he could, instead of laying him like that, because that's awkward. You understand what I'm saying, Dallas?
Like, you talking about like this?
Lay him on the lap. Yes, that's what most parents do. Boom, like that. There it is. But make sure you hold him so he don't jump, because he will jump. All right, sorry guys. I apologize. Mommy duty calls upon, so I have to stop in between and say some stuff.
Let's see. Where you putting that little booty at? Where you going? Trying to lift that. Oh, there go that bird now.
Okay, a third party claimed all belongings to him during the traffic stop per WSB TV anchor Mark Winnie. Because she put it in there, didn't that judge would see that this judge told her that cannot go back, overturn something. The judge threw it out. Being sneaky, my opinion, didn't think nobody was gonna read it because there's so many defendants and there's a lot going on. They was in that Maybach. Okay. He's still eating?
I break them in between.
Oh, good. That's smart. Okay, yeah. Sorry about that. I'm talking to the parent. All right, let's go back and finish reading this. All right, here we go, guys. All right, so, okay. According to the officer, he noticed his reflection in the mirror and the window of his patrol car, which told him that the window tint was too dark. The officer slowed down and got behind a Mercedes, which immediately turned into gated employee entrance of the Peachtree DeKalb Airport, and then pulled back onto Claremont, proceeding to the opposite direction in which it came. The officer continued to watch the Mercedes and noticed that the brake lights kept coming on, which made him, y'all really? You think that really happened that way? Which made him think the driver was trying to find somewhere to turn around and come back in the same direction as the airport. The officer remained in place as he predicted, the Mercedes came back up Claremont towards the airport, at which point the officer executed a traffic stop of the vehicle. According to the officer, approximately 2.5 minutes elapsed between the time he first noticed the window tint and when he executed the traffic stop. Okay? The officer exited his patrol car, and as he approached the Mercedes, he noticed that he was unable to see through the back rear or rear passenger window. The officer knocked on the window and instructed the driver, Sergio Giovanni Kitchens, to roll down all the windows because the officer was unable to see any other occupant. While standing at the back window, the officer could smell raw green marijuana coming from the inside of the car. The officer asked Kitchen and the other two occupants of the vehicle for their identification. Kitchen produced his driver's license, and the passenger, Williams, stated that he and the backseat passenger, Jones, had left their identification on an airplane. The officer ran the tag on the vehicle and learned that it was registered to Williams and called for backup. Y'all hear this, y'all? Okay, let me see if you guys hitting the thumbs up. Hit the thumbs ups while I read this. I'm reading. I'm live, Ruth. I'm not reading. Ruth is trying to give me the baby, y'all, while I'm on live with you guys. Peanut, she's trying to give you away. Look at her, y'all. She's trying to give the baby away. You okay, Dad? Yeah, look at her. Look at her. She's trying to give me Peanut. Look at Peanut right here. Y'all not responding to me, so y'all don't want me to keep reading. I don't hear no response. I don't see no response. You singing to them? You singing? You singing, Peanut? Did you burp him a second time? Oh. Peanut, your belly full? Oh, Lord, you're about to go to sleep on me. All right, y'all. Y'all not even trying to. Okay, thank you, Syria. You're the only one listening. Thank you, Sirius. That's you. You make me want to go ahead and read. Okay, let me finish reading. Okay, so he said he left his identification on the plane, right? The officer ran the tag on the vehicle, learned that it was registered to Williams, and called for backup. The officer told Kitchen that he smelled raw marijuana emanate from inside the car and asked if there was marijuana in the vehicle or on Kitchen's person. Kitchen responded that there was not and consented to a search of his person, which did not reveal contraband. A consensual search of William revealed he's Putin, Ruth. Ooh, he stink here. Oh, Jesus. Doo-doo. Oh, my God.
You made him real comfortable, Mom.
You funky, boy. Ugh, it stink. Sorry, y'all. He stink. He I think he doo-doo. Go in the other room. Dallas is kicking us out. Dallas is kicking us out, y'all. Hold on, y'all. Dallas is kicking us out. Let me finish reading this part. Can I finish reading, Dallas? Dallas is trying to kick us out, y'all. Hey, Talicia. Okay, let me finish reading this, and then I'll go because Dallas is trying to kick us out. All right, let me go ahead and finish. So, the officer told Kitchen that he had smelled raw marijuana emanating from inside the car and asked if there was marijuana in the vehicle, Kitchen or on Kitchen person. Kitchen responded that there was not and consented to a search of his person, which did not reveal contraband. A consensual search of William revealed approximately $3,000 in cash. When the officer asked him if he had any marijuana, Joan replied that they just done smoking. They just got done smoking marijuana earlier. Right? And hold on. The officer initially searched the car, revealed marijuana residue on the floorboard of the driver's side, and a full bottle of alcohol beverage behind the driver's seat, and a jar containing marijuana and 2 bottles of syrup in the armrest compartment. I'm sorry, armrest compartment. The officer placed all 3 men under arrest and continued to search the car, finding finding 2 guns, multiple miscellaneous pills, and a clear bag containing MDMA and a large stack of cash. Look, guys, so question, y'all. Hold on a second. Hold on. I got a question to ask you. So they question, okay, isn't Doug a rapper? Isn't Mr. Jeffries a rapper? So they think it's because he had that kind of money on him that he was being a drug dealer? So they're saying he was being a drug dealer? Is that what they saying? Oh, okay. So he's not supposed to have $3,000 in his pocket. He's yep. They know them drugs were for personal use. Yeah, if you have codeine, cold syrup. Hey, Kimberly. Yeah, because the drugs were there with the money. That. So, a celebrity rapper with a lot of money and some drugs, they think is a drug dealer trying to sell drugs. Oh, so that's the MO on that one. Okay. Got it. All right, let me finish reading because they had a large stash. They had $3,000 on them, but he was on the plane, right? They were at the airport. Okay. Following their arrest, William and Jones, the defendant, moved to suppress the evidence found in the search of William's car. At the hearing, the officer testified that the sole reason he stopped the car was because he believed the windows tinted violated Georgia law. But he didn't smell the marijuana, right? So it was because the tinted window, that's why he stopped him. Okay. Explaining the legal limits is 32 by the law actually reads plus or minus 3. That was below, so it was below 32, so there was no reason for him to stop them. Okay. According to the officer, he did not initiate a traffic stop of the vehicle when it pulled into the employee entrance of the airport because there was not enough room for him to pull his patrol car off the road. Instead, the officer elected to stop in the center turn lane of the road to watch the vehicle and decided to continue going after he observed their brake lights. So the brake light was broken? So the brake light was broken? I'm just trying to understand. Okay. Which he interpreted as a driver looking for a place to turn around. The officer testified that he told one of the backup officer about the suspicious maneuver with the turning of the opposite direction and the brake lights. That's when he made contact with car and he smelled raw green marijuana coming from inside the car. At the conclusion of the hearing, the trial court advised the state that it's going to be closed. Let me make this, everyone knows that. Therefore, the court granted the defendant motion to suppress. In the order, the court conceded that the officer testified unequivocally that the sole reason he stopped the vehicle was based on a supposed window tint violation of codified in OCGA 40-8-73-21B. The court went to find that, however, that there was no credible evidence presented whatsoever how the vehicle's window tinted violation OCGA 40-873-1B, OCGA 40-8-73.1C, 6D, there is no violation. So there was no violation in OCG 40-8-73-1B. When the window tint was darker before the factory delivered or permitted by law. So it was a factory made car. Okay. By law, federal law and regulation. Thus, without credible evidence, the tinted window was placed on this vehicle after being delivered by the manufacturer, and the stop of Williams' vehicle and seizure of defendant was illegal. Oh, snap. Did y'all hear that? Did y'all hear that? Did y'all hear that? So they stopped them because they saw, he said that the tinted window was too dark, right? But they found out that the car was done by the manufacturer of the car, so therefore it was not illegal. It was legally done. So whatever happened during that stop was suppressed. Wow, y'all, I'm learning a lot. I'm learning a lot. You know, guys, I didn't even know it because I've been hearing people throw out all kinds of like stuff in their channel, right? And nobody talked about this. You know that T Hootie? Nobody talked about this. You heard all these big bloggers and bloggers putting out all this stuff, but nobody's reading the documents. They're making false statements and stuff without reading these documents. Guys, this is crazy. This is so crazy. This is crazy. You seen it on the news? Okay. But why are they bringing it back into this case when it was already thrown out? Getty did it? Getty showed the evidence on this? Okay. He read that this was just done today. He read it today? Tihuti? Getty read it today? Because this was submitted today. Oh, he talked about no. He talked about no. What do you mean? I'm confused. He said he talked about no. What is he talked about no? Tihuti, help me out here. I'm trying to read what you say. You said he talked about no. Oh, he said he talked about this before? Getty talked about this before? That's what you're saying? No, they're not. Oh, you was answering me? Guilty. Okay. Okay, I'm so confused. You know, because it's a delayed in our conversation because, you know, I may ask something, then you answer it, and then I'm like, okay, what is she answering to? What? You know. So, okay, I got it. Okay, the news did. It's on YouTube. His lawyer is gonna fight extremely hard. Yes, he is. It looks like it. Dude, I'm trying. She said I'm silly. All right, let me go ahead and read this, right? But they rather go to the lies, y'all, because from what I have heard, okay, so Tahuti, so why are they bringing those charges of stuff that has been already thrown out? You see, they're part of his indictment. Hold his head, Ruth. No, his head is not on your arm. Now put his head on your arm. Thank you. Yeah, sorry about that.
These socks off. I can eat your foot. I'm gonna keep it still. I'm gonna eat it.
Getty's. What is Getty SPLE? What? Okay, now Tahuti, now you messing me up because I don't know what the word you just. What the heck is this? What is that? What's SPLE? Because everything is illegal. Double deputy, how can they? Well, you know that's going to be thrown out. You know that, right? Because if another lawyer and the judge, not lawyer, another judge has already suppressed it, he's going to suppress it as well. Because he did that with the last motion that I just read. Judge Glanville. Because if there's been a ruling done on it, the ruling has to stand unless it was overturned by the by the appellate court. There is a difference between suppressing the evidence and just throwing it out. But the last thing they remember the last one, it was suppressed and the judge confirmed it's suppressed. So suppressed means you don't bring it up. You don't ever bring it up. It says something about, you can't bring it up. I'm not a lawyer, so I'm just giving y'all my layman's opinion on this. I'm not a lawyer, so please do not take my word for anything, okay? Don't take my word for anything. This is a mess. If it's already got handled. Yeah. So, and folks, if the lawyer's bringing it up as something that was already handled, that means that the lawyer knows what they're talking about. He got the other one thrown out. So my theory, my opinion, it's probably the same thing is going to happen at this one too, because he has some backing of what already happened on a previous court by another judge. So what I'm trying to say is the same thing as being sealed. Same thing as being sealed. Oh, okay. All right, let me go ahead and finish reading this. I like reading this stuff. This is interesting. Some good stuff, right? Some good stuff, as Getty could say. Some good stuff. This is some good stuff. Shout out to Getty, who always give out these nuggets. Good stuff. He be cracking me up saying, this is some good stuff. Okay. The case was messed up from the beginning. Okay, that is why all the counts that Jeffrey had against him became less, because he threw a lot of stuff out because it was already from another ruling from another judge. And this one, in this case too. Yeah. And he also put the backings too, and this is the one with the Miranda rights not being read. So if he didn't read the Miranda rights, that's the trash. That's going in the trash. We already know that. If the Miranda rights has not been read, it's in the trash. You could forget that. because they have body cam, and the body cam would let you know whether or not they have the Miranda rights was done. So, well, and I guess they must have reviewed the body cam because they already said that Miranda rights was not read. So, how would they know that if they didn't listen to something to be concrete that they didn't read it? And most likely the body cam. All right, let's go ahead and finish this off. All right, let's go. Okay, and thus without credible evidence, the window tint was placed in the vehicle after delivery but manufactured the stop. Okay, we did that. It says it was illegal. Further, there was absolutely no credible evidence presented as to why this vehicle's window tinted violation, and that's 40-8-73-1B, to wit, the light was reduced as to less than 32% plus or minus 3%, and increased light reflection to more than 20%. Without this evidence, it is impossible for this court to conclude that this seizure was not based on a hunch and inclination, meaning that there was no real evidence of him. He just, felt there was something going on, and that's why he stopped them. He didn't have no what do you call it? Probable cause. Probable cause. What are you looking at me for, sir? Sir, what are you looking at me for? All right. Without this evidence, it's impossible for the court. Okay, I've read that part. The only evidence presented was that Officer Fikes could see himself in the window's reflection. This evidence does not conceive this court that there were specific accountable facts sufficient to give rise to a reasonable suspicion of the violation of OCGA. He's basically saying that even though you could see your reflection on the car doesn't mean that it was in violation. You're just speculating. You don't know what the violation code is, basically. So this is not good faith belief that the traffic violation is actually being committed. So that means that he didn't know for a fact there was a violation done, which would legally permit a stop of this vehicle as a credible evidence failed to articulate a factual basis for believing that this vehicle was in violation OGCA 40-8-73-1B. So the state appeals argument for that court erred by granting the defendant motion to suppress agreed. To justify a traffic stop, the officer must have an articulable suspicion of wrongdoing. An investigatory stop must be justified by objective manifestation that the person stopped is and is about to be engaged in criminal activity. A traffic offense provides the necessary fact for such reasonable suspicion, and when the officer witnessed a traffic offense, the result of a traffic stop does not violate the Fourth Amendment, regardless of the officer's motive for initial stop. This is what the argument was. Hold on. Officers believe that the suspicious windows tinted violate OCGA 40-8-73-1.1 is sufficient justified for investigatory stop, even if the officer later determined that the field test of the window tint did not, in fact, violate the statute. So that's what the argument was on that one. Expert on providing the code. Okay, we don't want to read all that because the code reduction 40%. Oh. Okay, these are the arguments. This is for the defense. Okay, we're going to keep going down. I could not validate the statute. Okay, says the trial court erred by granting defendant motion to suppress. It's a judgment reverse. Judgment reverse. Kuhn and Marco JJ concur. So it was a judgment, so it was reversed. What is a judgment reverse? Okay. So that was it on that. Diego, you came in late, sir. You're gonna have to go back and re-listen to the whole thing because we've been here for 2 hours and you're asking what's the latest update on the case. Well, he hasn't ruled on it yet, Crushy. The judge has to rule on it, so we got to wait. That was just submitted today. So he has to rule on it. And he just gave some backup stuff that the court's done. All right, hold on. Let me see what else is on here. I think that was it on that one. Let's see. I think that's it on that. Let's see what else is on there. So it's basically saying the Miranda part and also the it's going to be double jeopardy of the case. He's already been that has already been taken care of before. Now they're bringing it back up again. It's the same state and the same defendant. So that's what they basically saying, that they can't do this double jeopardy thing and then Miranda. So you got like 3 different reasons why this should be suppressed. So we'll see what the judge comes back with on the answer on that one. So he hasn't given a date when he's going to address that that motion. It was just submitted today. So see on this thing here, it was submitted today. Hold on, let me put that down. Hold on, we gotta look at the date so we know exactly. These were all the new stuff that was from today. These are all the new things that's from today. Today's the 20th, and this is what it was done for today. You see? Okay, I'm gonna go back up so you guys can see. It was done by today. Hold on. Okay, see, it was filed today at 10 a.m. this morning. So that was filed by Young Thug's attorney. So, sorry. You guys see that? That was filed today. Thank you, Crushy. So I am about to end this. I remember, guys, I told you I have the transcript. Okay, I have the transcript. So if you guys like to donate to assist me with some of the documents that I've been pulling up. Remember, these things are they are 50 cents per page of everything that you see me doing. Those are the things I have already paid for, okay? And I would like your assistance, and I don't mind getting it. but I need to replenish some of my funds on this, okay? And here's my Cash App, PayPal, Zelle, Vimo, okay? Any questions? Any question? You guys got any questions of me? We can go back up and see what exactly what. Let me bring it back up to the top. See what he's basically saying. You sleepy? You said he's not. Okay. So he's basically saying that he wants it suppressed because the initial statement made during the initial traffic stop, there was no Miranda rights. It says here, since the case has been already litigated, see, is considered to be double jeopardy, right? He said that on that. And then the other part, it says that Mr. William was not read his Miranda right. So those things in itself is violation. Well, the Miranda right part is a violation, so. Do you think the case will be dropped because of how the evidence was attained? I don't know. I don't know. I don't know. This is a lot. This case has a lot of twists and turns, and the reason why I say that because they have individuals who are on this case that have actually committed crimes who are in prison right now because their case was already done. So this is like it's kind of crazy that they're trying to charge. Most of this is going to be double jeopardy, I think. You know, but these other individuals have attorneys that are state attorneys, and to me, sometimes this is Sylvia's opinion. I'm just giving you my opinion, guys. Sometimes I think they work with the state. You know, when you're not paying an attorney, that's my opinion on that. You know, they're not going to fight as hard as for you as an attorney that you get on your own. Like Steele. I was looking back at the documents and stuff. Some of those attorneys have not put in not one motion. Not one motion. The last time some of them have a motion is back in last year. And I'm like, how do you see that you're going to be fighting a case when you haven't done any work? The only person who's doing the work is Shannon Stillwell's attorney. And you see Mr. Johnson did a couple of, you see, of course, you see Mr. Steele's putting a lot of motion. And then you see, what's the other one? There's another attorney that's doing Matthew said, free lawyers. Yeah, you're going to jail for a long time. I'll email you my information if you have any question about the Apple stuff. Yes, please, please, Sierra. Please, please, please. I need some help. I really do need some help. Trying to figure out then how to do these the uploads and stuff like that because I don't know how to do that. I have ProCut. Huh? Huh? She said I'm flip flopping. Did you help me yet? Okay, Dallas, help me. Oh Lord, you told me you didn't know how to do ProCut. I apologize, y'all. Okay, so I am done for right now. Anybody have any questions? Anybody have any question? I know I can't answer most questions, but I'll try. Oh, thank you. Thank you. Thank you so much for the Cash App. I got to do my, hold on. I got to do my sound effect. Hold on. I got to do my sound effect for one of my people who had just sewed into my life for this. Hold on. I got to do a money. Hold on a second. Where is it at? Not that one.
Money.
Hold on.
Money. Money. So much money.
That's my sound for money.
Money. Money. Money. So much money.
Thank you so much for the Cash App. Did y'all like that? Did y'all like that sound? Oh. Did y'all hear that sound? Oh, another Cash App. Hold on a second. Gotta do another one. Hold on. Y'all must like that sound then. Y'all must like that sound. Let me do it. Let me do it again. Let me do that sound again. Hold on. So yeah, somebody just drop a Cash App. I must like that sound. Hold on.
Money. 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 So much money. 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 So much money.
All right. Kimberly Williams says state attorneys do work with the state. I know this because my husband is locked up in Georgia. I'm a witness. Okay. Matthew says, I heard the Fed may try to charge them with RICO after the state trial is over. Listen, federal usually comes first. They'll take the case before state. That's what I was told. Federal don't come after no state. They look, they're gonna take over. They're gonna take over. They don't have to wait for this. They're gonna take over. They're not gonna let the state trial and then come back. No. They gotta be first. They will take it up first. So Matthew, that statement is incorrect. That is one thing I did find out. Federal like, we're taking this over and you step to the side. Let's handle this. We don't want you screwing up stuff that we have to do. Because they try to get it to go to the federal first. Doug is coming home. He's going to beat this case, bro. He didn't commit a crime, period. That's what Crushy says. Crushy's 365 says that. I'm talking about people just keep going, ignore the haters. Tehuti, I will definitely do that. I will keep going and ignore the haters because I just want to bring the facts to you guys. I want to read the paperwork, so I'm going to bring you that kind of stuff. You're not going to get my opinion. If I don't know something, I'm just going to tell you I don't know. If I spoke to someone about something and they gave me their expert opinion, I'll give it to you. And that came from someone who has family that works with the feds. That statement that I gave you a few minutes ago in regarding to federal government. They come in and get you first. They don't play. They're coming after you first. They ain't going to wait till the state to mess up. They want to come after you first. And they're going to come with a win. They want to win. They don't want to lose with you screwing up the case. And if the state screws up a case, I just emailed you. Okay, Sierra. Okay, let me look. Thank you, Trissy, and thank you, KDY. Thank you, you guys. Thank you for the 2 cash app that I got this evening. But anyway, guys, I'm about to go. And tomorrow I will have more time to read the transcript with you guys, because I did get the transcript. One was like 200 something pages, right? And the other one was less. It's going to be, you guys going to hear exactly what happened in court. Okay. All right. Good night, Matthew. Good night, everybody. Don't forget to say your prayers tonight. And I'll be on tomorrow. I decided to do my affirmation. I pre-recorded and I'm gonna send it in. Okay, Matthew, love you too. Thank you so much for being here. And see you later. Okay, see you tomorrow. If the Lord's willing, remember to say, if the Lord's willing, I'll see you guys tomorrow. Later. Bye, guys. I will kiss Pork Chop for you. He's knocked out right now, Black Beauty. He is knocked out. Mr. Pork Chop. See you later, guys. Love y'all. Bye.